If it may please the court, my name is HALA SANDRIDGE. I represent Lee Memorial Health Systems. I'd like to reserve 3 minutes for rebuttal, and I also would like to thank this court for accommodating my schedule this morning. We are here today because the insurance companies are trying to accomplish judicially what they have been unable to accomplish legislatively for many years, and that is to eliminate the Lee Memorial lien law. Initially, I'd like to focus on point 2 of my brief that relates to the lien law's unconstitutionality under Article 3, Section 11A9, and that prohibits special laws that creates liens based on private contracts. To fully understand the basis of our argument, I must first clarify important facts that are in this record. The form admission agreement that constitutes the contract in this case is a public document. It is a form on the website of Lee Memorial. It is a form that every patient fills out when they are seeking admission. It creates it contains no personal information, nothing confidential, not even a social security number.
Would you concede that the executed agreement is not a public document?
It is a public document.
Even when it's executed?
Yes, Your Honor.
Whatever the patient puts on there?
Yes. So even as executed.
It's available on the website. Where can the public find it?
The public, if it did a records request to Lee Memorial, it would be available. It is a public record, and it is kept as a public record. And the only additional information that it contains, if you look at the copy of it in the record, is the signature of the patient. It is not protected health information. It is not protected by HIPAA. It is a public record. This fact is very important because the 2nd District seemed to believe that this contract, it's the nature of it that creates it into a private contract, not a public contract. And our position is simply this, and it's almost deceptive in its simplicity. If this document is created in furtherance of the public business of Lee Memorial, then it is a public contract. It is as simple as that. There is no such thing as a private contract created by Lee Memorial. It can have none. Anything that it is doing in furtherance of running its operations and its public mission, which has been declared by the Florida legislature to be a public purpose. So every employee who signs one of these documents as a witness, I'm sorry, I misspoke. There's 2 signatures on this document. There is the signature of the patient and also of the employee who witnesses the signature.
Seems, I understand your argument, but it seems to me that you've got a piece of paper, and until someone signs it, it's not even really a contract. It's just a piece of paper, and it only is pertaining to, once it's signed, it is only applicable to the people who signed it. So I'm having a hard time following you that this is a public document simply because the public may have access to it if you go through all the hoops of getting, requesting it. But it's not a contract until somebody signs it, and only the people who signed it are bound by it.
So I would absolutely agree with you that it is not a contract until it is signed. And I don't think the issue here today is whether it's a public document. The issue we have to decide today is, what did the drafters of the Constitution mean when they used the term private contract? And that begs the question, what is a public contract? And here is our position, Your Honor, that when this document, which again is being created in furtherance of the business of Lee Memorial, which is a public body, and that's what its mission is. Its public purpose is to provide health care to the indigent. When that document is created, it is being done in furtherance of that mission. So I don't disagree with you that it's a contract between the hospital and the patient, but it is part of its public purpose. And there is no...
Aren't we supposed to read legal documents, the Constitution, statutes, in terms of the words in their common usage?
Yes, I think that is a starting point, but
You want to address the fact that that the second DCA and the parties apparently up to that point and even here have only found, in terms of common usage, public contract used to discuss a contract in which public funds are being expended. So, you know, I'm going to contract to build a road, something like that. I mean, that seems to be the common usage of that term, and you've come up with a rational, perhaps second way to view it, but I don't know, since you have found no authority that would support that other than your argument, I don't know how we could find that to be a common usage.
So I think it's common sense. First off, the idea that a public document a public contract is only a public works agreement, it can't make sense, because the state enters into so many different contracts, and we've cited a myriad of statutes that provide authority for the state to enter into contracts that have nothing to do with public works. And if you look at all of those contracts that are authorized by state, what they do address is the operations and the financing of the agency or the state that is asked to provide a certain service.
I'm still struggling with this being a public contract, because if there's a breach, once the parties have signed this document and it becomes a contract, does the public have a right to do something if there's a breach of the contract?
So the public doesn't have the right. Lee Memorial itself has the right, and Lee Memorial is the public body. And so Lee Memorial, a public entity, has many rights under that agreement that can be enforced. And so this gets to, again, a very organic level of what is the government. The government represents the people. When we have Lee Memorial entering into an agreement, it is entering into the agreement as a public agency that is authorized by the people to do what it's doing. So at its very basic level, our position is, yes, the public is represented by this document, and it gives Lee Memorial, acting on behalf of the public, pursuant to the mission that the legislator said was an important mission of providing health care to the poor, the opportunity to make sure that it recovers the finances it needs under that agreement to support its work. Now, I'd like to go back to something.
So, I mean, if Longwood, which was a party in a prior appeal this morning, their contract, similar admissions contract, would be a private contract. So if there was a similar statute that purported to provide a lien for Longwood Medical, then you would agree that that would be unconstitutional?
It is under Shands, the Shands decision from this case. That issue has already been decided,
Right.
I believe.
Right.
And that is the distinguishing feature between Shands and this case, which even the second DCA recognized was not resolved in the Shands decision. Justice Lawson, I'd like to go back to another point, too, of using common language. An important part of this is not only using common language to understand what the drafters of this constitutional provision meant, but to try and figure out their intent. And one of the amici parties
Would it be necessarily the drafters or the people that adopted the provision?
adopted the provision.
Okay.
I think it's fair to look at the information we have related to what they were considering at that time. And Allstate filed in its amicus brief a reference to a law review article that did a very thorough analysis of the constitutional history surrounding these hospital lien laws, and specifically this language. And very informative was a reference to a Florida bar-sponsored revision. And this was addressing this language before we reached the final language that went into this constitutional provision. And here's what the Florida bar-sponsored revision said. It wanted the language to read, instead of private contracts, except liens levied or imposed by municipalities. There can be no better evidence of what the drafters and those individuals who were participating in this particular constitutional provision than this type of evidence. We further provided, again, it came from the Law Review article, and it cites to the constitutional information that there was, during this entire time period, not pertaining to this specific 11A9, but to other areas of Article 311, big concerns about making sure that public liens were still going to be honored in light of these new constitutional amendments. And so if you take a look at not just the common language, not just trying to figure out what does this specific language mean in the context of ordinary...
They could have said liens of governmental bodies or liens by... Yeah, I mean,
And interestingly, that's what was suggested. And instead, what did they choose? Much broader language. They suggested imposed by municipalities. That would not include Lee Memorial, by the way, because we are not a municipality. And so what they did is they chose very broad language. They said private contracts, eliminating all public contracts, which opens up the door for not just municipalities, liens created by municipalities, but also for liens created by this particular public body that is not a municipality. So if you take a look at this specific language that was available to us to review what the drafters were thinking, what was surrounding this time period, you will see support for our position. I'd also like to touch on part of the analysis in the second DCA's decision that goes back to the first DCA's decision that came up to this court in Shands. And there's some very loose language contained in that case dealing with a lien on public assets, and this is not a lien on public assets, but a lien, and here's where I think both the second DCA and progressive goes astray. It doesn't say a lien on private assets. If you take a look at the language from the case, it's very, very specific. It says, we find that the lien does not attach to the public assets, but rather to the assets of the patient whose contract with the hospital is a private one. So even there, the analysis by the first DCA, before it went up to this court in Shands, didn't focus on the nature of the assets, but it being a private contract. And so to the extent that the second DCA believed that this court in Shands somehow approved the first DCA's rationale that because a public contract can have a remedy that permits a party to seek private assets to pay under the public contract, that somehow converts a public contract into a private contract, we would say, number one, that does not make sense, and we would say, number two, that is not what the first DCA meant, and number three, that this court did not adopt that in Shands. I would also like to discuss the portion of the opinion that if this court finds that this is constitutional, the court also found that the language in the lien statute that permits the hospital to obtain amounts greater than the amount that was liened creates some sort of unconstitutional impingement on the rights of the insurance companies. First, I would like to say that to the extent that the second DCA believed that this was facially unconstitutional, it cannot. There are many scenarios in which, let's say you have a policy for $50,000 and the lien is $5,000. Certainly, there would be no scenario where the lien could exceed the policy amounts. So to the extent that the second DCA declared this to be facially unconstitutional, it's incorrect. But even if you take a look at it and assume that in every case, the amount of the lien is going to exceed the amount of the policy proceeds, all we are looking at right now is determining whether or not there was a rational basis for the legislator to do what it did. To give an incentive to the insurance companies, yes, it may be a bit of a hassle, but to pay the hospital lien. And if you choose to not do so, if you choose not to protect yourself by either paying it directly or putting it in the court registry or writing a joint check, they have a lot of options here, there's a penalty for it. And the penalty is you may have to pay more than the amount of the lien. That is a rational legislative objective. It is consistent with other statutes such as the construction lien laws, and it is our position that it does not afford a basis to find this lien law otherwise unconstitutional. So with that, I would like to reserve the rest of my time for rebuttal. Thank you.
Good morning, and may it please the court. My name is Valerie Dondero with Kubicki Draper, and I represent the APPELLEE Progressive Select Insurance Company in this claim. This morning, we are here asking this court to affirm the Second District's ruling, the trial court's ruling, granting summary final judgment in favor of Progressive and declaring the Lee Memorial Lien Statute, just that Section 18, unconstitutional under Article 3, Section 11A9, and as the Second District addressed, also Article 1, Section 10.
Just on the facts of this case, and I understand there could be a case where there's $1 million in insurance and the lien at $5,000 and the insurance company ignores it. As we know, as a practical matter, the insurance company does a lot with the settling party to ensure that medical bills get taken care of where there's insurance. What are we dealing with here? The Progressive had a $10,000 policy?
That's correct, Justice.
And the amount of the lien that they're asking you to pay is how much?
The lien is $84,199 for 2 separate hospitalizations, and Progressive's policy of insurance with its insured was a $10,000 per person bodily injury liability coverage. So in this instance, and referring to Lee Memorial's argument that there are some opportunities, if you've got $1 million policy and the lien is $20,000, that it can be paid.
But that would be,
still,
just on that, because they're talking about whether it's facially unconstitutional or as applied.
Correct.
Really, the issue of how much the lien is and how much the policy is doesn't affect whether they've got a greater right than another hospital who, you know, who always asserts the right to get recovery, and the insured or the injured party negotiates. And
that's entirely correct. And they don't have any greater rights than the patient could actually assign under that hospital admission contract. So for Lee Memorial to suggest that an injured patient gets $10,000 because that's all there is in coverage, but is then penalized, Progressive in this instance and other similarly situated insurers, of course, are penalized by not protecting Lee Memorial and then being exposed to what basically amounts to extra contractual liability, attorney's fees, costs, which are all part of Florida's bad faith laws that are not incorporated into this lien. So when Lee Memorial talks about the penalty that an insurance company suffers in failing to protect that lien, it really does create bad faith extra contractual exposure to insurance companies without Lee Memorial having to jump through the statutory hoops of 624.155 in Florida's civil remedy statute. But there's,
Let me see.
Yes, Justice.
Did Progressive tender to Lee Memorial the $10,000?
there were two payments, $10,000 in bodily injury liability coverage tendered directly to the patient once his lawyer refused to continue on with the case. Progressive then tendered an additional $10,000, which was the maximum PIP coverage, personal injury protection coverage, directly to Lee Memorial because the patient was on a bicycle and he didn't live with anyone and he didn't own his own motor vehicle. So Progressive also paid the PIP as technically a pedestrian under the PIP statute. So there were two actual $10,000 payments.
But did they, in the settlement with the, then the individually was not represented by anybody in the settlement?
At the time that the claim was initially presented to Progressive, the patient was represented by Morgan & Morgan. And the record will reflect that Morgan & Morgan did stop representing the patient because of the inability to settle the lien with Lee Memorial.
And so when Progressive then tendered or accepted, when the insured, I don't know, no, the insured wasn't, I'm sorry, the plaintiff got the money. Did Progressive say that he had to protect the Lee Memorial lien out of that?
Yes, that was part of the settlement. And of course, that did not happen, as in many instances, the correspondence between counsel for the patient at that time, he was virtually unemployable and homeless, and there was a request that the entire lien be waived because of financial hardship. Lee Memorial refused, and here we stand. But under Section 11A9 of Article 3, there can be no special law, as we know, but there's 4 separate prohibitions in that prohibition itself. It's a prohibition on the creation of a lien based on a private contract. It's also a prohibition against the enforcement of the lien based on a private contract, the extension of the lien, or the impairment of the lien based on a private contract. So there's actually 4 prohibitions within 11A9. So initially, yes, the lien is created upon the hospital admission contract, and that certainly is a private contract. Not because I say so, but we know in the First District, in the Mercury decision, which this court acknowledged and ratified, there's an actual description and a definition of why that was a private contract. It wasn't because Shands was a private hospital. In fact, nobody ever mentions that Shands is a private hospital. Shands, in fact, is a not-for-profit corporation who qualifies as a charity under IRS code. The reason it was a private contract was because Shands provided medical care and treatment, in that instance, as here, on an emergency basis, for which then the patient owed a debt to Shands for repayment. That's the private nature of the contract, not because it was a private hospital or a charitable hospital. The Mercury decision never makes that analogy. This court, in the Shands decision, never makes the statement that this is a private contract because Shands is a private hospital. And there is certainly plenty of case law where, if you look at public entities, they can enter into private contracts. And we know, just from looking at the lien statute language itself, that Lee Memorial can enter into contracts of all kinds. It doesn't say public contracts of all kinds, and it certainly could have. The lien statute says Lee Memorial can enter into contracts on various subjects with public and private corporations and entities. Entering into a hospital admission contract with one person for their personal medical care and treatment is a private contract, just like Mercury told us and just like the Second District told us in this case here. If you look at that hospital admission contract, it is not a form contract that doesn't have any personal issues attached to it. It does. The patient has an unconditional guarantee. That's the language of the lien of the hospital admission contract. He has to assign his rights to payment of his bills from Medicare, Medicaid, third-party liability insurance, health insurance, whatever that patient had in the way of an asset, he assigned to Lee Memorial. Those are his private insurance contracts, his private health insurance, his private Medicare and Medicaid insurance. Those assets belong to the patient. They don't belong to the public, and they don't belong to Lee Memorial. They belong to, in this instance, the patient, Mr. Galejos. Shands and Mercury disposed of this issue when this court ruled in 2012 that this type of a lien law, which if you compare the language from the Alachua County ordinance that was at issue in Shands to the lien law that's at issue here for Lee Memorial, they're almost identical verbatim language. It is a special law that created a lien based on a private hospital admission contract. But then it goes one or two steps farther. It created a lien based on the hospital contract, but then it enforces that lien not based upon the hospital admission contract, but it enforces the lien against the progressive policy of insurance. That's another private contract. It provides a source of recovery for impairment of the lien based on the private insurance policy that Progressive had for its insured. That's another private contract. So it is not sufficient for Lee Memorial to suggest to this court that because its hospital admission contract is a public contract that they have escaped judicial scrutiny under Article 1, Section 11A9, because they have not, because they have enforced, extended, and impaired liens. They have created a special law for that enforcement and for that impairment based on the private contract that Progressive had with its insured. How do we know that? Because Lee Memorial wants $84,000, which is 8 times the amount of insurance coverage that was purchased by Progressive's insured. Plus attorney's fees, plus costs. A non-party to that insurance policy has greater rights than was ever contracted for between Progressive and its own insured.
Separate and apart from the lien, did this action or this case or this dispute ever become involved with the question of payment over and in the face of the assignment of benefits that existed before the payment was made?
I'm not sure that I follow your question, Justice Lewis.
You described that there's a full assignment of benefits. You do understand what an assignment is, I know.
I do.
And you know what benefits are, and you know what it means when an individual assigns benefits of some kind to somebody, right?
Yes.
That's what I'm asking. So the question was, separate and apart from the lien, was it ever litigated or in dispute in this matter as to whether the payment to the insured over, notwithstanding the benefits had already been assigned to the hospital in this case? separate and apart from the lien concept.
No, I don't
Okay.
believe that it was. But even under assignment law, Lee Memorial gets no greater rights than the patient actually has. And if the cause of action is for personal injury to, against, in this instance, the tortfeasor was Progressive's insured, Progressive has a policy of insurance and a duty of good faith and fair dealing towards that insured
Well, I
to
mean,
pay
you've got
that claim.
even, there are other problems with it. I mean, you cannot assign a tort claim.
Certainly.
But you do have the medical benefits, those types of payments that I believe can be assigned to someone.
And Progressive
And-
paid the PIP under that.
Well, I understand. I do understand that, and I agree with you that I don't know of any theory that would elevate it to the full amount of their bills that were there. But I do wonder as to whether when an insurance company pays over an assignment of benefits, like a medical benefit that can be assigned, whether that insurance company may be responsible for having to pay it again, up to its policy limits. But if this has not been discussed, that I'm just talking, so.
It's an excellent point, it really is, but under assignment law, obviously, it would not be an assignment of any greater rights than those that any patient would have
Oh, I
had
agree.
or
I agree
first-party
totally.
insured.
I agree. It's a question
Right.
of protecting the benefits and the one who actually provides the services, so.
Indeed.
And I do see that there's a significant difference between Shands, a private hospital, and a public hospital that is sponsored by the government and funded by the government. So anyway, you answered my question. Thank you.
Thank you, Justice. But, you know, even if there is a difference between who Shands is and who Lee Memorial is, they don't provide different medical care and treatment, which is what this hospital admission contract created a lien on. They still both provide the same types, hopefully, of care and treatment. And remember, when Shands was before this court, there was an amicus presented where the Florida Hospital Alliance was attempting to create a public pact argument. That was exactly their words, saying, hey, listen, this isn't a private contract that we have for medical care and treatment. We have to treat everybody under emergency laws. We have to, everybody that comes into our emergency room has to be treated. And so that's what we did under our public pact, our public purpose, our public obligations. And what did the court rule on that? We find that the assets that the lien attaches to are not public assets. They are the assets of the insured. In this instance, the assets of the patient, who has a private contract for medical care and treatment with Shands. It's the same here, Justice Lewis. It is the same because there is no difference in a public versus a private hospital in the rendition of medical care and treatment. They can still enter into a private contract. The fact that they are a public hospital does not change that fact. The fact that Lee Memorial can suggest that this hospital admission contract is a public record. The bottom of that hospital admission contract says it's a medical record. It's part of a medical record for that particular patient. So the public records argument, unavailing. The issue on the limitation of recovery, if this court finds that that statute is constitutional, which we suggest it cannot under the holding in Shands and our argument in our briefs presented here today, Lee Memorial is now in a position to have greater rights under a policy than anybody else would in the state of Florida, and certainly without following any of Florida's bad faith or extra-contractual statutory general law provisions. And that simply cannot stand. Here, Lee Memorial gets to control the claim. Lee Memorial gets to control the litigation, if there is any. Their statute allows them to interplead right into any litigation. It has an opportunity in the first part of their statute, Section 18 of the statute, creates the lien on the cause of action or the settlement. And then the second part of Section 18 tells us how they want to go about and enforce it. And that enforcement then becomes punitive and extra-contractual in nature because it seeks recovery of extra-contractual damages, in this instance, 8 times what there was in insurance coverage that the insured never paid for, that Progressive never accepted a premium for, and allows Lee Memorial to pursue a recovery that is even outside the scope of the lien that it creates under the first section of the statute. If the statute says the lien is based on the settlement, that settlement was $10,000. So you can't have a second part of that statute say, well, the lien's only going to be on the settlement, but we're going to collect the full reasonable cost of our lien in punishment for not protecting us. Insurance companies have significant duties and obligations to their insured. They cannot prioritize a hospital in one county over their duties statewide to every one of their insureds that they have issued a policy to. They have duties of good faith and fair dealing to settle cases when it's reasonably apparent that it needs to be settled, and that's exactly what they did. And that's what they continue to do because that is their regulated, highly regulated obligations in the state of Florida. If there are no other questions, we would ask the court to affirm the second district and find this statute unconstitutional. Thank you so much for your time this morning.
Thank you. So what you heard are complaints about what the legislator did. And it is not up to this court to rewrite the lien law to make it easier for insurance companies. What they are complaining about is that they have to follow the law. And I would add that it would be impossible for them to be violating their good faith towards their insureds when they are following the law, which is incorporated into the policy.
So let me ask you, so the practicalities of what you're saying for this case, do you agree they paid their $10,000 in PIP to the hospital?
They pay the $10,000 in PIP to the hospital.
Is it that because they paid the additional $10,000 to their insured, not their insured, to the injured party rather than to you, if they had paid the $10,000 to the hospital, would that have been the end of what Lee Memorial would have sought from Progressive?
That would be the end of it. And I want to add a fact that is important here. There was another insurance company involved in this, MGA, who we also sued and who paid the $10,000. This is after we filed suit. That was the end of it. That's all was the end of it. Practically, once they pay the $10,000, we can't get any more than that. And so it ends at that point. Another point I'd like to make.
So again, so the position, and again, obviously a law firm couldn't, because you wanted the whole amount, and there was a very injured person, there was, I guess, it's either give it all to the hospital or walk away. But you're saying, again, that the lien, if you didn't have this special law, you agree that that result, that is, you've got to pay or you're going to be on the hook for all of it, would not pertain to other hospitals that are not public hospitals?
No, actually, there are ordinances. And this was part of the Shands decision. So many, like Shands, which is not a public hospital, it has a separate ordinance that does this. And so it is allowed to obtain a lien on the proceeds. I can't tell you right now what amount that particular ordinance allows them to get, but most of the public and private hospitals have ordinances throughout the state. A key fact here is that Lee Memorial doesn't. It just has its special law. And so we are not doing something that is unlike what other private and public hospitals are doing. So another important point here is this idea that the contract in any way contains private terms. Every person who enters into this contract knows that the person sitting next to them is agreeing to all the same things. And Justice Lawson, getting back down to a very granular level again about what is private and what is public. Private is something that is a secret. Private is something I keep to myself. When something is public and everybody else knows what is happening, how could that information in that contract be private?
You make a lot of good points, but saying that that's what private means, we have private businesses, private practice, none of that connotes secret societies. I mean, I think that that's, if it's granular on the wrong side of.
And so, Your Honor, here is what I would say, and this probably brings us full circle. This is an issue that's never been decided by any court. What is a public contract? What is a private contract? But what this court has to decide today is, what did the drafters mean when they used the word private in the Constitution? Thank you.
We thank you both for your arguments. That is the final case on today's docket. The court will now be in recess.